Good afternoon, everyone. Thank you for joining us for today's online talk, which will be starting shortly at 3 p.m. For those of you who are here early, thank you for waiting patiently. While waiting, we would like to share with you a short video from the firm.
I founded the firm in September 1985 with the vision of seeking truth and justice for our clients and not just winning their cases. Over the years, the team has achieved many significant milestones. We are today recognized by the Legal 500, Asia Law Profiles, and Asian Legal Business as a recommended firm in various practice areas. While we have embraced technology to make our services efficient and responsive, we continue to grow on the bedrock of meticulous preparation and hard work, for which there is really no substitute. As legal practice becomes increasingly international, we keep ourselves ahead of the curve with our relationships with lawyers from around the world. Our firm is a founding member of the League of Lawyers, a growing international network of law firms in 20 Asian and European countries.
We believe in partnering with our clients to protect and grow their business. We achieve this by holding firm to our values of integrity and justice, while giving our best to deliver effective and efficient solutions. Instead of just legal services, we focus on developing great working relationships based on understanding and respect.
We regularly advise foreign clients, including many Chinese investors, and have a ready appreciation for different ways of doing business. In corporate matters, we offer relevant and commercial solutions, often raising issues that clients may or may not have realized before. In negotiations, we believe in facilitating win-win outcomes.
Welcome back, everyone. Thank you for joining us for today's online talk titled Annual General Meetings for Stratified Developments, Essential Insights for Developers, JMBs, MCs, and Property Managers. My name is Sebastian Liew, and I will be your moderator for today's session. Before we start today's talk, let me introduce the firm and what we do. Ma Wing Kwai and Associates is a mid-sized law firm that was founded in 1985 by Dato' Ma Wing Kwai. Our team today is 28 lawyers strong and a support team of 21. Dato' Ma is today a consultant with the firm following his retirement from the Court of Appeal bench in 2015. The firm continues its tradition today of working primarily with SMEs, family, businesses, and individuals. We are a full-service law firm with a corporate department, a dispute resolution department, including litigation, adjudication, and arbitration. We also have a dedicated employment and industrial relations team and a department focused on servicing the needs of individuals and families. Our practice groups indicate some of our focus areas, which are supported by talents from both our corporate and dispute resolution teams. Today's talk is part of our MWKA online talk series. By way of background, we have been organizing monthly lunch talks at our office since 2013. Some of which were also broadcasted live. Since the COVID-19 MCO, we moved online in order to continue with our objective of sharing knowledge, raising awareness, and encouraging networking for clients, potential clients, and in-house counsel. Before I continue, please be reminded that this talk does not constitute legal advice. In the event you require specific legal advice to your matter, please contact us for a complimentary legal consultation. Details will be given at the end of the talk. We have two speakers for today, Daphne, Rethual, and Fung. Allow me to first introduce Daphne. She is a senior associate in our dispute resolution department. She graduated with a Bachelor of Laws from the University of London. Daphne was admitted to the Malaysian bar in January 2019. Her areas of practice include general litigation, debt recovery, joint management body disputes, probate and administration, and contentious probate litigation. Our second speaker, Carmen, is an associate in our dispute resolution and our individuals and families department. Carmen graduated with a Bachelor of Laws from Cardiff University. She was called to the Bar of England and Wales in November 2018 and admitted to the Malaysian Bar in 2020. Her practice areas include general and commercial litigation, probate and the administration of estates, joint management body matters, and family law matters. If you have any questions, please feel free to post your questions in the Q&A box below. Our speakers will respond to them at the end of their presentation at our Q&A session. For today's online talk, we have in total 5 talk points. The talk points will be divided amongst our speakers. Carmen will be speaking first on point 1 and point 2, being the duty to convene annual general meetings and the pre-annual general meeting requirements. Daphne will be speaking after, and her talk points will be on point 3, point 4, and point 5, being the eligibility to vote at annual general meetings, the types of resolutions at annual general meetings, and the election of management committee members. I will now pass the floor over to our first speaker of the day, Carmen.
Hi, everyone. Thank you, Sebastian, for the warm introduction, and good afternoon, everybody. My name is Carmen, and I will be addressing the first 2 talk points for today, which are the duty to convene Strata Management Annual General Meetings and the pre-annual general meetings requirements. First of all, let me introduce the relevant legislation that governs strata management in Malaysia. Firstly is Strata Management Act 2013, which many of you will call it as Act 757. Next is Strata Management Maintenance and Management Regulations 2015, and also the Strata Titles Act 1985. Bear in mind that the Building and Common Property Maintenance and Management Act 2007 was repealed on the 1st of June 2015. So in today's talk, we will be largely focusing on the Strata Management Act 2013. Strata Management Act 2013 is an act to provide for the proper maintenance and management of buildings and common property and for other related matters. However, the SMA is a relatively new legislation as it came into effect in 2015, but we are still seeing the full application of the Act or court coming to decisions or cases being deliberated on the issues related in the SMA. Coming to our first talk point, we'll talk about the developer's management period to JMB. It is the duty of the developer to convene first AGM of the JMB. Section 18 of the SMA stipulates that the developer must give a written notice of the first AGM to all purchasers not less than 14 days before the meeting. The written notice must be displayed at a conspicuous part of the development area. Next is to prepare and place before the first AGM for consideration an annual budget that sufficiently sets the expected and estimated expenditure required to properly maintain and manage the building, which shall be for a period of 12 months, starting on the first day of the month, following the date of the first AGM. So for an example, if the first AGM of the JMB is to be held on 29 March 2023, the annual budget should be prepared from 1st of April onwards till 31st of March 2024. Section 19 of the SMA provides the agenda of the first AGM, which includes but not limited to determining the number of members of the JMC and to elect the members of the JMC. To also consider the annual budget prepared by the developer, to determine the amount to be paid by a parcel owner as the charges and contribution to the sinking fund, to determine the rate of interest payable by a parcel owner in respect of any late payment of charges or contribution to the sinking fund. In short, we'll call this as late payment interest. Other agendas include to consider the audited accounts during developer's management period, to confirm the taking over by the JMB of insurances effected by the developer, to make any additional bylaws, to consider any other matter connected with the maintenance and management of the common property of the building. However, these lists are just a guide, and the JMB can include any other agenda related to the development to be discussed and determined on the first AGM. So what happens if the developer fails to convene the first AGM? Section 18 sub 2 of the SMA provides that any developer who fails to convene the first AGM of the JMB commits an offence and shall, on conviction, be liable to a fine not exceeding 250,000 or to imprisonment for a term not exceeding 3 years or to both. However, do take note that Section 18 sub 2 is just a general provision. For some developments with unique situations, it shall be considered on a case-to-case basis and to be determined and taken up at the court. So we'll look at the general timeline to recap on the transition from the developer's management period to JMB. So the first part of the timeline shows the developer have 12 months after the vacant possession to convene the first AGM of the JMB. That 12 months period is called the developer's management period. The JMB will be established on the first AGM itself, and after the convening of the first AGM, the developer then have a month to hand over all the administrative matters related to the development, hand over it to the JMB. We will consider the first MC's AGM on our next point. So what if the MC is established before the first AGM of the JMB? Let's first understand the opening of the strata register and also the establishment of the MC. So upon the issuance of strata titles, the land office will also open the strata register. The MC will then come into existence on the same date when the strata register is open. The land office will also issue a certificate of establishment of the MC. After the issuance of strata titles in the developer's name, the developer will then commence the perfection of strata titles with each of the purchaser. Next, I will be explaining what is initial period, which will be useful later. So let's look at what the provision says about initial period. Section 46 of the SMA provides that an initial period is in relation to an MC, means that the period commencing on the day on which the MC comes into existence and ending on the day on which their proprietors, excluding the original proprietor of the lot of land or the developer who is registered as the proprietor of a parcel or parcels, or a provisional block or blocks, the sum of whose share units is at least 1/4, which is 25% of the aggregate share units. So to simplify Section 46, an initial period is the period between the establishment of the MC until there are parcel owners having a total of at least 25 aggregate share units, which excludes the original proprietors or parcel owners which are originally held by the developer. The duty of the developer to convene the first AGM of the MC is provided in Section 57 of the SMA. So Section 57 provides that the developer shall convene the first AGM of the MC within a month after the expiration of the initial period. The same thing, developer shall give a written notice of the first AGM to all purchasers not less than 14 days before the meeting. And also similar with the first AGM of the JMB, to prepare and place before the first AGM for consideration an annual budget that sufficiently sets out the expected and estimated expenditure for a period of 12 months, starting on first day of the month following the date of the first AGM. Section 58 of MA further provides the agenda for first AGM of the MC. It is largely similar to the provision for the first AGM of the JMBR, but I'll just briefly repeat here again. The agenda includes to determine the number of the members of JMC and also to elect the members of the JMC, to consider the annual budget prepared by the developer, to determine the amount to be paid by a parcel owner as the charges and contribution to the sinking fund, to determine the rate of interest, which is the late payment interest, to also consider the audited accounts, to confirm the taking over by JMB of insurances affected by the developer, to make additional bylaws, and also to consider any other matters connected with the maintenance and management of the property. Similarly, if the developer fails to convene the first AGM of the MC, sections 57 sub 2 of the SMA states that they will be liable to a fine not exceeding 250,000 or to imprisonment for a term not exceeding 3 years or to both. Within 12 months of vacant possession, if there is already an opening of strata register by the land office and the proprietors have a total of 25% of aggregate share units, the developer can then commence the first AGM of the MC within a month after the expiry of an initial period. After the convening of the first AGM of the MC, the developer has 1 month to hand over all related matters to the MC. On our second top point, we'll discuss in detail about the pre-AGM requirements, such as what should the developer or management prepare before the AGM. For this point, we will largely on the second schedule of the SMA. For this slide, we'll see paragraph 12, sub 1, provides that a 14 days notice of AGM must be given to every parcel owner. So if you wish to convene your AGM on 30th April 2023, you shall provide your AGM notice not later than 16 April 2023. And of course, you can give earlier notice to the parcel owners on the AGM. The notice of AGM can be served by several manners. Firstly, by hand with proper acknowledgement from the parcel owners in writing, by registered post address to the last known address of business, parcel, or residence of the person to be served, or by attaching the notice or order in a prominent part of the last known address of business, parcel, or residence of the person to be served. As repeated in my earlier points, the notice of AGM may be displayed at a conspicuous part of the development area, such as at the notice board, leaves, or at the management office. Moving on, we'll then discuss on what shall the management include in the AGM notice. Paragraph 12, sub 2 of the second schedule provides guidance on what information to include in the AGM. Firstly is the basic info such as the place, date, and time for the AGM, the proposed resolution to be considered at the AGM, and each parcel owner's voting rights to vote in person or by proxy at the meeting. Paragraph 12, sub 3 of the second schedule further provides the documents to be attached with the notice. So you can attach a copy of the minutes of the last AGM, a copy of the audited accounts together with the auditor's report on the accounts of the JMB, and also the information on any other matters to be considered at the meeting. For any parcel owners who wishes to include a motion in the agenda for the AGM, the person may do so under paragraph 13 of the second schedule, and this may be done by way of notice in writing, and it must be deposited at the registered office of the management corporation not less than 7 days before the AGM. Next, paragraph 14 of the second schedule further provides that the management committee shall put up a list of names of the persons who are entitled to vote at a general meeting on the notice board at least 48 hours before the general meeting. It is also a common practice to include in the notice of the AGM that a parcel owner may appoint a proxy to attend and vote during the AGM, provided that an instrument of appointing a proxy shall be deposited at the address of the JMB at least 48 hours before the time of the AGM. So if you wish to appoint a proxy to attend and vote on behalf, please do so 48 hours before the AGM. This will then lead on to the issue on eligibility to vote in the AGM, and it shall be discussed by my colleague Daphne. With that said, this is a time to pass the floor to Daphne to take over for the remaining top points of the day. Daphne, over to you.
Good afternoon, everyone. Thanks for the introduction, Sebastian, and thanks, Carmen. Today, I'll be addressing the third, fourth, and fifth top points, namely the eligibility to vote at AGMs, types of resolutions at AGMs, and the election of management committee members. First, who is entitled to vote in an AGM? You will only be entitled to vote if you're a proprietor who 7 days before the AGM has no arrears. As paragraph 21, sub 2 of the second schedule to the Strata Management Act says, a proprietor shall not be entitled to vote if on the 7th day before the date of the meeting, all or any part of the charges or contribution to the sinking fund or any other money due and payable to the management corporation in respect of his parcel are in arrears. Next, on the voting rights of proprietors. Each proprietor who is not a co-proprietor, meaning you don't jointly own one of the parcels with someone else, shall have one vote in respect of each parcel on a show of hands, and on a poll shall have such number of votes as that corresponding with that number of share units attached to his parcel. So for example, if you own 5 parcels and the method of voting at the AGM is by way of show of hands, your one hand would be equivalent to 5 votes. Since you have 5 parcels, if the voting is by poll, it will be corresponding to your share units. Next, how do you vote if you are a co-proprietor? If you are a co-proprietor, say you jointly own a parcel with someone else. Co-proprietors may vote by means of a jointly appointed proxy. Let's say 2 of you own this parcel. You may appoint one person, an outsider, or by appointing any one of them or any other person to represent you AGM. So it can be one of you, or you can appoint a third party. In the absence of proxy, co-proprietors shall not be entitled to vote on a show of hands, except where a unanimous resolution is required, provided that any one co-proprietor may demand a poll. Once a poll is demanded, the person chairing the AGM will have to proceed by poll. On a poll, each co-proprietor shall be entitled to such number of votes attaching to his parcel, as is proportionate to his interest in the parcel. How do you appoint a proxy? This is addressed by paragraph 18 of second schedule to the Strata Management Act. So if you're an individual proprietor, you may appoint your proxy by writing and signature. If the proprietor is a company, society, statutory body, or any other body, this, for example, company may appoint a proxy by way of seal or under the signature of an officer or its attorney. The instrument appointing the proxy must be deposited at the registered address of the management corporation not less than 48 hours from the date of the AGM. As this was also addressed by my speaker earlier. Can a proxy represent 2 proprietors at an AGM? No. The answer is no. Paragraph 18 sub 4 of the second schedule to the SMA says, a person may act as a proxy for only one proprietor at any one general meeting. Who can be appointed as a proxy for a non-individual proprietor? Say the proprietor is a company or a statutory body. So paragraph 23 of the second schedule to the SMS says, a proprietor who is not a natural person may be represented by a meeting by. So for example, if it is a company, it can be represented by its representative authorized under its seal, or authorized by its director, or by its authorized attorney. If the company is under a receiver or receiver and manager, the receiver or the receiver and manager may appoint the proxy. And if the company is under liquidation, the liquidator may appoint the proxy. And society can be, the proxy can be any one of its office bearers or any other person duly authorized. If it's a statutory body owning the parcel, any one of its members or any other person authorized can be the proxy. Next, we move on to the types of resolutions that can be tabled at AGMs. What are the types of resolutions under the SMA? So generally, there are 4 types of resolutions. The first one would be ordinary resolution. Second would be special resolution. Third would be a comprehensive resolution. And fourth would be a unanimous resolution. We'll look at the ordinary resolution first. The ordinary resolution is basically a resolution that covers all matters that affect the daily management and maintenance of the development. As my co-speaker have mentioned earlier, you will be required to give 7 days notice, and such resolutions would be considered carried if it's passed by a simple majority, meaning 51 to 49%. It can be decided by a show of hands or by vote. A special resolution is defined under Section 2 of the SMA, which means a resolution which is passed at an AGM of which at least 21 days notice specifying the proposed resolution has been given and carried by a majority consisting of not less than 3/4 of the valid votes casted. So earlier, Carmen mentioned that notice of the AGM has to be given 14 days ahead. So how do we overcome this? The practical solution would be probably don't wait until you receive the notice of AGM to put in such a resolution, probably do it ahead. As generally AGMs would need to be convened every 15 months latest. It's usually annual, but maximum you can go without is 15 months. So put in your resolution as soon as the thought comes to you. And special resolution can be voted by show of hands or poll as well. When is a special resolution relevant? A special resolution is relevant where there's intention to make additional bylaws or amend the additional bylaws. So the bylaws are actually provided under the third schedule of the Strata Management, Maintenance and Management Regulations 2015. You may make additional bylaws or amend the bylaws, but you can't add or amend it in a way that is inconsistent with the current bylaws. And also, a special resolution may also be relevant if you would like to introduce or take out an insurance against other risks other than the fire insurance. So the fire insurance is generally mandatory under the SMA. The management has to take out a fire insurance, but let's say management decides to take out an error and omissions insurance to cover the potential mismanagement or negligence claims against the JMB and MC members. You have to move a special resolution to take out such an insurance, or even other insurance such as burglary or theft policy. These are insurance not mandatory under the Act. The next resolution we'll be looking at is the comprehensive resolution, which is also defined under Section 2 of the SMA, which means a resolution which is considered at a duly an AGM of the management corporation, of which at least 30 days notice, specifying that the resolution has been given. And at the end of the period of 60 days after the AGM, this comprehensive resolution would be voted on a poll. So meaning you have to give 30 days notice from the AGM, and then after this AGM has ended, the voting would take place over the span of 60 days after the AGM. The total of the share units of the parcels for which valid votes are counted for the resolution is at least 2/3. So it would require 2/3 of voters to carry, and it can only be by way of a poll. When would a comprehensive resolution be relevant? The comprehensive resolution is only relevant for the purpose of creating limited common property and designating subsidiary management corporations. So for example, you have this development consisting of a mall and then a residence and then maybe a hotel. And then you are let's say the proprietors are of the view that the hotel is solely used for maybe people occupying the hotel and running the hotel, people from the residence and the mall generally don't cross over. So they would like to create a subsidiary management corporation and then classify the hotel area as the limited common property. They would have to move a comprehensive resolution. So when limited common property and a subsidiary MC is formed, they can have separate accounts from, let's say, the residence and also the mall. So it's like their own little MC separately. The process is a lengthy and quite a comprehensive one, and can only be done by way of a comprehensive resolution. So limited common property is defined under Section 2 of the Strata Management Act, which is referred to common property in a lot that's designated in a comprehensive resolution referred to in Section 17A of the Strata Titles Act for the exclusive benefit of the proprietors of 2 or more, but not all parcels, and for which a certificate has been issued by the director certifying that the sub-MC has been constituted under the Strata Titles Act. Now, Section 17A of the Strata Titles Act say the management corporation may designate limited common property and create 1 or more subsidiary management corporations only for the purpose of representing the different interests of parcel proprietors by way of comprehensive resolution conducted under the SMA. The formation of sub-NC and designating of limited common property can only be done at the management corporation stage and not before, not at the JMB stage. This brings us to the last resolution, which is a unanimous resolution, which is defined under the Section 2 of the SMA, which means a resolution which is passed at an AGM of which at least 21 days notice has been given and carried by every valid vote casted at the AGM by a show of hands or a poll where a poll is demanded. So this one as well, it can go by hands or poll. Only the comprehensive resolution would have to be done, or it can only be done by way of poll. So when is a unanimous resolution relevant? Unanimous resolution is only relevant under one circumstances is when a management corporation wishes to acquire land outside the lot or to grant or accept the burden or benefit of an easement on the lot. So this is provided for under Section 74 of the SMA, which says MC, if authorized by a unanimous resolution, may acquire land outside the lot or to be used by the purpose connected with the subdivided building or land, grant or accept the burden of an easement imposed on the lot for the benefit of some other land, or accept the benefit of an easement imposed in favor of the lot or on some land. So that's the end of the resolutions. Next, we will look at the election of management committee members. So let's look at the formation of management committees. This is mainly provided for under paragraph 2 of the second schedule to the SMA. Generally, under the SMA, to form your management committee, the committee itself may consist of 3 to 14 members elected at AGM. So this would also include any member, is inclusive of any member of the sub-MC of a subsidiary management corporation. So the minimum number of members is 3, and the maximum you can go up to is 14. So there shall be a chairman, secretary, and a treasurer elected after the AGM by the members. And no chairman, secretary, or treasurer shall hold office for more than 2 consecutive years. This office bearer shall automatically retire after the conclusion of the next AGM. A retiring member of the management committee shall be eligible for re-election, but no member of the management committee shall hold office for more than 3 executive terms. So who is eligible? Anyone who is at least 21 years of age, who is a proprietor or a co-proprietor of a parcel, and is nominated for election by a proprietor, or is not a proprietor, but is a member of the immediate family of a proprietor who owns 2 or more parcels and is nominated for election by the proprietor, may be eligible for election. Who is not eligible for election? A proxy is not appointed. A proxy appointed by a proprietor is not eligible for election. An individual who is a co-proprietor of a parcel, if any other co-proprietor of that parcel is also a candidate at that election, meaning the 3 of you owning it, and then one of your co-proprietors is running election, you can run as well. An individual who is nominated for election by a proprietor who owns 2 or more parcels, if that proprietor together with any of his nominees nominated at the same election or elected to the management committee at the same or other election exceeds the threshold number for that proprietor. So what is this threshold number that we are speaking about? Threshold number is the number of management committee members that is proportional to the proprietor's share units, ignoring any fraction, or 49% of the number of management committee members, ignoring any fraction, whichever is lower. So for example, the total number of committee members to be elected at this AGM is 5 persons. If you're a proprietor who owns 3 parcels, and your 3 parcels, the share units of these 3 parcels amount to 45% of the total share units, and you are standing for elections with 2 of the nominees, this is not allowed because all 3 of you would constitute 60% of the committee. Let's say all 3 of you are elected, you would actually form the majority, and that's not allowed. So in such circumstances, only 2 persons may be nominated. Then these 2 persons would be 40% from the committee that's elected eventually. An absent proprietor is also not eligible for election unless he has appointed a proxy and has given his written consent for himself to be nominated and elected as a member of the management committee. Next, we'll look at the vacation of office of the members of management committee. This is covered under paragraph 2 of the second schedule to the SMA. A person who is the chairman, secretary, or treasurer of a member of a management committee shall vacate or shall be deemed to have vacated his office as such member if he resigns, dies, becomes a bankrupt, no longer a proprietor, convicted on charge in respect of an offence involving fraud, dishonesty, and moral turpitude, an offence under any law relating to corruption, an offence under this act, or any other offence punishable with imprisonment for more than 2 years. Okay, you will also be deemed to have vacated your office if your conduct, whether in connection with your duties as a member of the MC or otherwise, has been such as to bring discredit on the management committee. If you're of unsound mind, or if the person is a chairman, if he absents himself for more than 3 consecutive scheduled meetings of the management committee without leave of the management committee, you are deemed to have vacated your position. And then if you're not the chairman, you're anyone else in the committee, if you have absent yourself 3 consecutive meetings without the leave, without approval from the chairman, you have also you will also be deemed to have vacated your office. Other circumstances where someone would have been considered to have vacated their office is where the proprietor of a parcel is a company, society, and statutory body. By resolution, be removed as the representative of such company, or if this person is in default of maintenance charges, contribution to the sinking fund, including interest, for a continuous period of 3 months, or in the case of a member of the management committee, if he commits a serious breach of the bylaws and has failed to remedy the breach. If the breach is capable of being remedied within 14 days of the date of receipt of notice of such a breach from the management committee. That brings me to the end of my session. I will pass the floor back to Sebastian. Thank you.
Thank you, Daphne and Carmen, for your insightful presentation. We will now begin the Q&A portion of the session. We will give the first question to Carmen. What if first JMB annual general meeting notice issued and strata register is open? Convene first AGM of JMB or MC?
Yep, so I'll take this question. What if the first JMB AGM notice is issued and the strata register is open? If the JMB is ready to convene the first AGM and at the same time the strata register is open, then the first AGM of the JMB shall not be required to convene. It is in section 17 sub 5 of the SMA, and also section 17 sub 3 of the STA, Strata Titles Act, states that the MC is established when strata register is open. So you do have to convene the first AGM.
For the second question, Daphne, the management committee members stated a regulation in the notice of the annual general meeting to parcel owners that no one shall be allowed to record by means of video or audio proceedings of the general meeting. Can the management committee create such a one-sided regulation arbitrarily? Would such regulation be enforceable? How does such regulation affect transparency of what actually transpired during the meeting versus what is minuted in the minutes?
There's no express law on this. If you think that such a ruling is unreasonable, and if you wish to challenge the validity of the proceedings of the AGM for some reason, if you think that there's some sort of inconsistency between what happened and what was minuted eventually, you may want to challenge it in the tribunal. But there's really no express law to say whether you can record or can you not. If for some reason you question the propriety of the AGM, then maybe it's something that you would have to take up with the tribunal.
We have a question for Carmen. Richard Tan bought 2 properties in KL and Johor under his name and his wife as purchasers and owners. Is his wife a half owner of the properties, and does he need to make a will in the event of his passing so that the properties will be solely owned by his wife? Does he need to make a will using a Malaysian law firm? And do we have a branch in Johor? Can he make a valid will using a Singapore law firm, or must it be a Malaysian law firm so that there will not be problems subsequently in case the Malaysian courts do not recognize the will made in Singapore due to procedural oversights?
So this question is more on the appropriate administration of the property, but I will answer that. The short answer is yes, it is 50-50 share in the property. So the husband will need to write a will to give the 50% share of the property to the wife. You can also use the Singapore law firm to do the will. There's no issue because Malaysia recognizes all Commonwealth countries' will, and the will will still be enforceable in Malaysia. You can opt to do it in Singapore or either in Johor. That's fine.
The next question is for Daphne. How should a voting right of a parcel owner be specifically worded in a notice of general meeting?
I believe the template for such notice is in the SMA or the regulations. You may want to check in the SMA or the regulations. If you're unsure, maybe you can reach out to us separately after the talk. Thanks, Sebastian.
Thank you, Daphne. Next question is for Carmen. What happens if the developer goes into liquidation prior to the opening of the strata? Carmen.
Yeah, so for this, if the developer has gone into liquidation, unfortunately, the liquidator will then take over on the management of the property, and the parcel owners will have to deal with the liquidator, including to pay for the application of the strata titles as well. So you will deal with the liquidator for a short answer.
Let's have Daphne for the next question. And can paragraph 21 sub 2 be varied, i.e., the MC allows proprietors to pay up to 10 a.m. of the AGM, day where the AGM is scheduled at 2 p.m. Then the MC allows those who have paid on that day to participate and vote in the AGM.
The short answer is no. You can't vary the provisions under the SMA or the SMR as and when you like. So if you think this can be varied and then someone comes and challenge it, again, the validity of the AGM might be in question.
I will direct the next question to Carmen. Can we do digital notice such as QR code? Carmen?
According to paragraph 12 of the second schedule, as pointed out earlier, AGM notice can only be served by hand or by registered post or by attaching the notice at the last known address of business. Short answer is, according to second schedule, you cannot do a digital notice.
Thank you, Carmen. The next question will be directed to Daphne. Can I be denied from voting at an AGM, assuming I've fully paid the service charges, but the tenant has not settled the water charges?
So generally, the JMB or the MC is only entitled to collect maintenance charges and sinking fund contributions from proprietors. So technically, if you have paid your maintenance and your sinking fund contributions, you should be allowed to vote.
The next question will be for Carmen. After a notice to requisition for motions to be included on agenda for general meeting has been filed, can the general meeting vote to not entertain the motion? Carmen?
I will take this question. The short answer for this is no. All the motion posed by all parties shall be considered in the general meeting. And if you are against the motion, you can vote against it, but you cannot compel the general meeting to vote not to entertain the motion.
The next question is for Daphne. Special resolution will not be carried out during the AGM since it needs 30 days and the AGM notice is only 14 days.
Correct. So like I mentioned earlier, the way to overcome this is probably to put in your proposed resolution or motion the minute it comes to mind and not wait for the notice of AGM to reach, because the notice of AGM is only going to be sent to you 14 days from the date of the AGM. So if you could send it earlier, then perhaps what the MC or the JMB can do is to give 30 days notice of the upcoming AGM to table for the purposes of tabling the special resolution. Thanks, Sebastian.
Thank you, Daphne. The next question is for Carmen. Do you need a special resolution to increase service charges or sinking fund? Carmen?
Yeah, so the answer is yes. Any increase or the changes to a service charges or sinking fund must be done through a resolution.
The next question will be for Daphne. If I am the developer of a certain project and also assuming sufficient share units or parcels have been successfully transferred to the purchasers, I now wish to call for an AGM to form the MC, but there is insufficient quorum. What can I do?
I think the SMA is provided for, like it provides for situations where quorum is not achieved. So under paragraph 15 of the second schedule, which addresses quorum at general meeting, it says 1/2 of the proprietors entitled to vote present, either in person or by proxy, shall constitute a quorum at a general meeting. If within half an hour after the time appointed for a general meeting, a quorum is still not present, those proprietors entitled to vote who are present shall automatically constitute a quorum. So the AGM will still proceed. Thanks, Sebastian.
Thank you, Daphne. As we are short of time, we will only be taking 2 more questions. One for Carmen and one for Daphne. The next question will be for Carmen. Let's say 100 unsold units out of 400 That's 25%. So effectively, vote by shares just bypass vote by unit, allowing developer to have more say? Question mark. Carmen.
Yes, so I have mentioned earlier, the 25% of the aggregate share units does not include the share units for the developer as well. But the answer for this is yes, but while developer has more share units, you are saying that they have more say. Comparatively, the developer will also have to pay more maintenance charges because maintenance charges are in proportion to their share units. That's my answer for that.
Thank you, Carmen. And the last question for Daphne. In respect of proxy of a corporate body, can other proprietors request for a copy of the authority given to the said individual by the corporate body for inspection?
No, the SMA or the SMR does not empower other proprietors to question the eligibility or the authority to vote. I think the duty lies on the JMB or the MC to verify such authority, and it's not for your fellow proprietors to question. Thanks, Sebastian.
Let me just clarify on my earlier answer on the increase of the maintenance charges and sinking fund. I mentioned that we will need a general resolution to increase it, but you do not need a special resolution for increase of service charges and sinking fund.
Thank you once again, Daphne and Carmen, for your insights on the Q&A session. Before we conclude, I have just a few announcements to make. Please join us again for our upcoming talk on the 5th of April 2023. The topic is the future of sports sponsorship in Malaysia, and the speakers for the talk, Leslie Lim and former Olympian Jeffrey Ong. Please fill in our feedback form and tell us what you thought of our talk. The link to the form will be posted in the chat. Do also follow or like our social media accounts. We have accounts on YouTube, Twitter, Instagram, LinkedIn, and Facebook. If you would like to speak with our lawyers, we offer a complimentary 30-minute consultation over the telephone or over video conference. Please fill in the form on our website. The link is posted in the chat box. To our guests, thank you for joining us. We hope you found today's session informative and useful. Thank you, everybody.